Yes, it's the time that we should resume the meeting. Eric, please proceed with the scrutiny of the bill. Please continue leading us in the clause-by-clause examination. We're on clause 64. We are also repealing the reference to a registered non-Hong Kong company and substituting it with the company. Clause 65. We're amending section 791. Company must deliver return for registration in case of change of certain particulars, and we are making changes so that for registered non-Hong Kong companies, they would have to comply with this requirement. Clause 66, a supplementary provision for section 791. Clause 67, Financial Secretary may make regulations. This is section 804, and we have repealed the part about registered non-Hong Kong company and substituted it with company incorporated outside Hong Kong, to which section 790 applies, so that the provision will also accommodate the changes in section 790. Starting from clause 68, we will add part 17A so that we can set out the procedures and responsibilities of redomiciled companies. So there are 8 sections, 820A to 820H. Excuse me, please wait. Mr. In Kong. Chair. The administration talked about the section for financial secretary making regulations. There is a definition in B. For many changes that you made, you talked about corporations outside Hong Kong, and we have in other sections the word corporations. That is essentially non-Hong Kong incorporated companies. But under companies ordinance, we talk often about companies instead of corporations. So can you tell me why sometimes you would use the word corporation, why sometimes you would use the word company? Why is there a distinction in the word used? In other jurisdictions, they would not use the word corporations. They would use corporate entities. So I want to know, why are you using the word corporations? DOJ. Thank you, Chair. Thank you, Member, for your question. For companies incorporated outside Hong Kong, it is a definition set out in Chapter 622. If you look at Section 2 of Chapter 622 for the definition of body corporate, it would include companies or body corporates incorporated outside Hong Kong. So this is equivalent to the English text, what is said in the English text, because we need to include a company incorporated outside Hong Kong. So incorporated in Chinese would say 成立為法團. Excuse me, I'm not an expert in company law, but when I first saw this, I had this question in my mind: what is corporation? What is a company? I think the approach that they're adopting is not exactly appropriate because we have redomiciled companies being companies already. Why wouldn't we need another word, corporations, for this? So you can just call the companies companies. Why is there the need to call the companies corporations? If you need a new definition for this, and I would support it if it is necessary. But when it is unnecessary, it can be confusing. Chair, this is just a suggestion. DOJ, any response? Companies registry or the DOJ, any response? Dr. Junius Ho. I think we can refer to the practices overseas. I'm not a company law expert either, but in BVI or Cayman Islands, they would allow companies outside their jurisdictions to redomicile to their jurisdictions. I don't know if their approaches work the same way as our inward redomiciliation regime. If they allow in law inward redomiciliation before, for companies incorporated outside BVI or Cayman Islands, they can just move their companies without re-registration. Is it possible we can refer to their practices? Because I think their redomiciliation systems are quite mature. I think we can model our system on theirs for reference. So I want to ask specifically what their inward redomiciliation regimes are specifically. Deputy Secretary, can you give an answer to the members' questions? Let me put it simply. We have an inward redomiciliation regime to have companies with outward redomiciliation regimes, that the jurisdictions that they're located in, they can redomicile to Hong Kong, and they would have the jurisdictions will also need to have a regime for outward redomiciliation regimes, and they would need to have proof shown from the other jurisdictions that the companies are redomiciling to, that the companies have already redomiciled to the other places, and they need to have members' approval. I'm not asking this question. I'm asking for companies redomiciling to Cayman Islands. Do they have inward redomiciliation regimes? What are their operational details?
Well, the bill is very thick, so members were asking whether things could be made simpler. So my question is, if in BVI and Cayman Islands, they allow companies to redomicile to their jurisdictions, what would their laws be? Do they have a bill as thick as ours? I don't have information about how thick their bills are, but we have made reference to the inward redomiciliation regime of other jurisdictions. According to their laws, they look at the background of the companies. Yes, you have to check all this information, but we are scrutinizing this bill, and this is a very thick set of bill to amend Cap 622. And this bill is about the inward redomiciliation regime. So what I'm asking is, for the jurisdictions that have in place an inward regime, do they have such a thick set of bill as well? If they adopt the same practice, I just want to know if they do the same to their laws when they implement an inward regime. Administration, this bill is about our requirements for companies redomiciling to Hong Kong. And in each provision, we have to add a supplementary provision. This is because the original company's ordinance only applies to Hong Kong incorporated or Hong Kong registered companies. So we have to amend the ordinance so that the legislation will be applicable to redomiciled companies. We heard members' views about whether we can have a consolidated section for all these supplementary provisions. We will think about this. On Ms. Kong's question about the definition of corporations, is there anything to add by the administration? Yes, Ms. Doreen Kong. I have a suggestion for Part 17A. For all the parts that mention about non-Hong Kong corporations. Well, I've looked at the definition of company, and according to your definition on page 2, it covers redomiciled companies. So I don't think there's a need for us to talk about corporations in Section 8A4. I've looked at the laws of BVI and Cayman Islands, and they use the reference companies only. I don't think we need to create another term, corporations, in this bill. The administration has taken note of members' suggestions. Let's see if the administration has anything to add. If not, please carry on with Part 17A. Section 820A, page 125 of the marked up copy. This section is to introduce certain definitions and interpretations, including the certificate of redomiciliation, application date, redomiciliation form, and so on. Section 820B is about the application requirements. The company will have to submit the relevant forms as well as the articles. Ms. Carmen Khan, I want to ask about Section 820B, subsection 1C and subsection 1D. Mentions about a public unlimited company with a share capital and a private unlimited company with a share capital. What are the considerations behind when you decided to include these two types of companies? For the 4 types of companies set out under Section 820B, they are the 4 out of the 5 types of companies that could be registered in Hong Kong under the existing companies ordinance. We did not cover limited by guarantee companies, and they are mostly NGOs. Well, we abide by 2 principles. For a company redomiciling to Hong Kong, they have to be regulated by the company's ordinance. We have drawn reference from the relevant laws of other jurisdictions. Our consideration is that when a company is redomiciled to Hong Kong, it has to comply with the existing company's ordinance. We include the 4 out of the 5 types of companies that can be incorporated in Hong Kong here. We have considered the market demand as well as our policy intent, and that's why we are including the 4 types of companies here under Section 820B. Chairman, is it the same in other jurisdictions? Do they allow the type of companies to be redomiciled to their jurisdictions based on the types of companies that can be incorporated in their jurisdictions? Would they allow trustees or funds to redomicile to those jurisdictions? On the types of companies covered here, we have drawn reference from the redomiciliation regimes in Australia and New Zealand. They have a similar requirement. The companies that could be redomiciled to these 2 countries, they have to correspond to the types of companies that could be incorporated in those places. How about trustees and funds? They could not be redomiciled to Hong Kong. They have to be registered in other places first, like Delaware. When the DOJ decides, well, what is the DOJ thought on this when we decide which types of companies to be covered here? DOJ, we want to introduce a regime to allow companies to be redomiciled to Hong Kong. LegCo Brief, paragraph 29, mentions that back in 2021 for non-Hong Kong fund corporations and limited partnership funds, under Cap 571 and Cap 630, they have been allowed to redomicile to Hong Kong, and this mechanism has been effective. That's why we are extending this redomiciliation mechanism to other types of companies. Under the existing companies ordinance, we have 5 types of companies, and we are excluding limited guarantee from the 5 types of companies that could be redomiciled to Hong Kong. For the other 4 types, they have to comply with all the laws in Hong Kong like any other types of companies incorporated in Hong Kong. And it is only these 4 types of companies that we accept their applications to redomicile to Hong Kong. Well, I believe this is part of the amendment to Cap 622. Yes, Ms. Doreen Kong. Can I ask about Section 820B? Yes. Subsection 3A2. It talks about Schedule 6A, 6B, and 6C. I'm looking at Schedule 6A to 6C. You are showing the entire application form here. The administration mentioned about Singapore, New Zealand, and Australia. I want to know if they have dozens of pages like Schedules 6A to 6C in their laws. Can you simply say forms required by the registrar? Why do you have to set out all the schedules here? What is the purpose? This is very clumsy. I want to know if in other jurisdictions they list out all the schedules in their laws. Yes, PAS. We've drawn reference from the incorporation system for companies in Hong Kong, so we are sticking to the same framework and standards. We've also made reference to the practice in Singapore. For all the documents as well as information that have to be submitted, they are listed out in the law. Why don't you use the wording like prescribed form of the registrar? Ms. Doreen Kong's comment is, why make it so clumsy? What if you have to amend the schedules? You'll have to initiate another legislative exercise. You're right that in Singapore, there are regulations to deal with these procedures. They do not set out all the details in their major provisions. Deputy Secretary. We set out all the requirements as well as documents to be submitted in Schedule 6A to 6C to give certainties to companies so that they know what kind of requirements they have to meet. And this is in line with our existing companies ordinance for locally incorporated companies. If in future we have to revise the schedules, this can be done through negative vetting. This is to ensure consistency within the company's ordinance. This is also to give certainty as well as flexibility for future applicants. Chairman, I think there is a difference between ordinance and regulations. I hope the administration can think about how we can make use of our regulations in future legislative exercises, instead of setting out all the details in the major provisions.
Okay.
I believe the DOJ notes your comments. Please move on. Eric. Thank you. Section 820C. Consideration of application and registration by the registrar. In subsection 2 in particular, if any of the requirements mentioned in section 820B is not complied with, the registrar must refuse to register the applicant. Also, if an applicant is believed to be operating for an unlawful purpose or is contrary to public interest, the registrar must also refuse the application. The section also provides for the registration of documents, and the registration begins to have effect on the date of issue of the certificate of redomiciliation. Please pause here, Ms. Doreen Kong. Thank you, Chair. I have questions about subsections 2 and 3. These are about the registrar having to refuse application. But in subsection 2, it says must refuse, but in subsection 3, it says may refuse. But it seems that subsection 3 is more serious because the intended company may likely be used for an unlawful purpose or for a purpose contrary to public interest. Why is it that in subsection 3 it says may refuse instead of must refuse? Thank you. Eric, we are using must refuse in subsection 2 because in accordance with section 820B, the requirements are factual. And the registrar has a duty to refuse the application. But then when the intended domicile company is likely to be used for an unlawful purpose or for a purpose contrary to public interest, the registrar has to make assessments. It is relevant in the sense that the registrar may be providing an opinion or is exercising judgment. It relates to the power of the registrar, not a duty of registrar. That's why we are using may in subsection 3. Chair, I have a follow-up question. So if you are saying it relates to the power of the registrar, wouldn't it be the case that there would be more disputes that may arise. I think the member is asking whether there will be higher chances of judicial review or CR. DOJ, any comments on this? Thank you. Member, for all public officers' decisions, they are subject to judicial review. I think the company's registry colleague may supplement my answers, but the registrar of companies must have justifications and grounds for making a decision, and they must be reasonable and fair when making the decision. Under the legislation, the registrar has the power to refuse the application when the domiciled company is likely to be used for an unlawful purpose or for a purpose contrary to public interest. And we said in our response to the assistant legal advisor's letter that this decision is subject to judicial review. So how the courts view this, it would be their decision, and the public may lodge a judicial review to object to this decision made. While that is how it works, we need to make sure we are reflecting that it is the registrar's power to refuse to register the applicant. Assistant legal advisor, I would like to supplement the members' questions in the sense that we asked the administration whether the registrar must provide reasons. And they said the registrar would give reasons. I want to ask then if they will provide in the bill's provisions the registrar will provide reasons, because we have seen in other legislation specifically that the relevant public officer must give reasons. Deputy Secretary, we have referred to existing provisions when drafting this. We want to maintain consistency in the approach that we take for Hong Kong incorporated companies and redomiciled companies. So right now in law, you do not require the registrar to provide reasons for rejecting applications from Hong Kong incorporated companies. In general, the registrar would provide reasons, but is it provided in law? Well, for Hong Kong incorporated companies, it is not spelled out in the provisions that reasons should be provided, but reasons will in general be provided. Mr. Kong, I think the administration should give us a written reply. I think they shouldn't just give their reasons in one sentence. I need a more detailed reply. Say in subsection 3, we're talking about, say, for a purpose contrary to public interest. In other jurisdictions, they would say the registrar must refuse the relevant application. I think we should be clear as to why we are saying may refuse the application here. This is for the reference of future applicants. I think the administration's explanation is not very clear, to be honest. There will be essentially an appeal mechanism if they object to what you said or the grounds you gave. Say it is contrary to public interest. Well, at least an appeal mechanism is available in other jurisdictions. Do we have an appeal mechanism here with this bill's provisions? Deputy Secretary. As the DOJ colleague said, these decisions are subject to judicial review, and like Hong Kong incorporated companies, this is the approach taken. Mr. Kong, I think we do not have to go extreme in the sense that we will need to have judicial reviews for everything. In Singapore, it says specifically if people are not satisfied with the registrar's decision within 30 days, they may lodge an appeal, and the appeal can be dealt with by the relevant bureau, but the decision will be final then. So I think if you're just saying people can lodge judicial reviews to decisions, it seems that we are not very open to companies coming. I think the administration can refer to the approach taken in Singapore. Alright, administration, please review this and provide a written response to Ms. Doreen Kong's concerns. Ms. Carmen Khan. Thank you. I would like to follow up on what Ms. Doreen Kong said, and Ms. Doreen Kong talked about how it works in Singapore. It would say specifically, contrary to national security. It is a particular reason, and we have talked about this at the meeting last time. The administration has been quite clear in their response that for potential national security risks or with contrary to public interest, they think the current provisions should be adequate to address such. But I think, as Ms. Doreen Kong said, if we add a term contrary, or when it is contrary to public interest, when we're talking about national security threats, would you providing a ground saying that contrary to public interest or contrary to national security would be different? I understand what you are saying, that you would in general give reasons, and that would be comply with common law. I am not so concerned whether you should really put this in law giving reasons, but I think you should say must refuse, because it is what is adopted in Singapore. And the registrar, if you say may here, may not refuse the application. So I think it is more proper to say must refuse here to address the national security risks. Thank you. Deputy Secretary. We have talked about why we drafted the provisions this way in our response. But let me say this, the operation is the same for redomiciled companies and Hong Kong incorporated companies, and please rest assured public officers have the duty to uphold national security, and when exercising the power they will have regard to that. As my colleague said before, we're using may because it is a power to be exercised by the registrar. The member wanted a written response, and we can provide in the response additional information on this. I think they should give us some analyses and maybe some comparisons in the written response. Alright, the administration is to give a written reply. Mr. Poze. Well, I want to say this, the response given by the administration, they talked about in page 3 in the UK, Singapore, Australia and New Zealand. It seems that Singapore has a stricter regime. And honestly, Singapore has quite harsh punishment. Maybe we should not have reference to Singapore's regime, and I think we can perhaps follow the UK's proposals. We can just have an assessment made in Australia and New Zealand. They have quite loose regimes. If the intent is to have a looser regime, I think we should not follow Singapore's regime. But let me say this for the words must and may. In section 820C, the premise seems to be that it should apply to companies that have yet to register in Hong Kong. In subsection 2, they are saying must refuse. They talked about this requirement being factual. But I think why not adopt a lecture approach to say may refuse in subsection 2 also, because this is also essentially a power of the registrar, and in the end, if the decisions made are not satisfactory to the applicants, they can always lodge judicial reviews. Why not maintain consistency by changing must to may in subsection 2? Deputy Secretary, we have explained why we use the relevant words, and I said before we will provide a written response to address the concerns of members. Dr. Junius Ho. Sorry, I'm a little slower. Are you talking about subsection 3 of section 820C? If the intended redomiciled company is likely to be used for an unlawful purpose or for a purpose contrary to public interest, you are talking about how with this you would address potential national security risks. Yes, but they're not actually mentioning national security. But then in the national security law, once the National Security Committee has made a decision, that decision is not subject to judicial review. So here in subsection 3, you talked about the company likely to be used for an unlawful purpose or for a purpose contrary to public interest. It seems to have a lower threshold than national security. If you're talking about addressing national security risks, it would have a higher threshold. I think when it involves national security, whether it's company's ordinance or other legislation, and once the Committee for Safeguarding National Security of the Hong Kong SAR has made a decision, it is not subject to appeal or judicial reviews. I think we should clarify the situation. Thank you.
福利呢個位
DOJ. I thank the member for the question. On unlawful purpose or purpose contrary to public interest, if you take its literal meaning, it covers the considerations for safeguarding national security. As mentioned, we will, in our written reply, address the question of what will happen if the unlawful purpose or purpose contrary to public interest has to do with national security, including whether a JR could be filed. We will provide a written reply. Thank you. Ms. Doreen Kong, on Section 820C, I have another question. Subsection 2. States that the registrar must refuse to register an applicant under subsection 1 if any of the requirements mentioned in section 820B that are applicable to the application is not complied with. Well, this has to do with the policy. The business environment has been changing every day, and we are trying to trawl for companies to come to Hong Kong. We want to therefore look at the practices in other jurisdictions. According to the laws of other jurisdictions, the registrar has the power to waive or modify the relevant conditions. The merit to this practice is that we can't be sure what the actual situation be, because different countries and places are competing for companies. So I think it is crucial that we allow for this flexibility. Will the administration consider this? It doesn't have to give me an answer now, but can it look at the practices in other major economies? Do they provide a level of flexibility in their legislations? The administration may give a written reply to this after the meeting. Members' comments noted. Yes, Mr. Eric Lee, please carry on. Section 820D, page 130 of the marked up copy. It's about the effect of registration under Section 820C. Under this section, a body corporate does not have the effect of creating a new legal entity. And this regime does not affect any function, property, right, privilege, obligation, or liability acquired by the body corporate. And it does not render defective any legal proceedings commenced or continued by or against the body corporate. Section 820E sets out the deregistration requirement. The redomiciled company will have to, within 120 days, deregister from the original domicile, and the registrar may, where appropriate, extend the 120-day period. Section 820F sets out the consequences if the redomiciling company does not comply with the requirements set out in the previous section. The registrar will give no more than 30 days for the companies that fail to meet the requirement to give a representation. And where appropriate, the registrar will have to gazette the revocation order and serve the order on the body corporate concerned. Ms. Kamen Khan, I think the Section 820D has to be drafted in more details because it has to do with the effect of registration. It sets out the consequences where the body corporate concerned fails to deregister from the original domicile. It is said here to avoid doubt on or after the redomiciliation date. Any legal proceedings that could have been commenced by or against the body corporate may be commenced or continued by or against the redomiciled company. That means, in case there are litigations, the body corporate concerned would not be able to carry on with the litigations that have been taking place in the original domicile. Will we have to refer to the laws of the original domiciles to see if there are any conflicts between our law and their laws? Deputy Secretary, let me brief you on this provision first. It says here to avoid doubt. It means if the company is redomiciled, there won't be a new legal entity created. This is to ensure the continuity of the legal identity of the redomiciled company. DOJ, as we drafted the bill, we took into consideration this. What does a redomiciled company mean? Say, if there are unfinished legal proceedings, how should the body corporate deal with them? We'll have to look at the decisions of the courts to see whether there are conflicts in laws. If there are, the court will have to decide, as a court in Hong Kong, say a litigation is raised by a redomiciled company or a third party. And the Hong Kong court will have to decide whether it has the jurisdiction to continue with handling the case. So there are very complicated considerations behind to decide whether there are conflicts of laws. This has to do with how the courts in Hong Kong perceive this. We can't list out all the scenarios here, so we use the word to avoid doubt here. While a company may be redomiciled to Hong Kong, it doesn't mean that a new legal entity is created. And it also doesn't mean that the subsisting legal entity has disappeared. It's just that the redomiciled company will have deregistered from the original domicile. We don't think it is necessary to list out all the scenarios that may arise in the bill. Chairman, we have to ensure the clarity of Section 820D. The wordings to avoid doubt is used here. However, I think it's more appropriate for the administration to explain the reasons why it drafted subsections 1 to 5 here through a written reply. It also talks about tax purpose here. If you are to draft it this way, you have to explain which laws you made reference to. To show us your justifications. Administration, please give a written reply on the entire Section 820D. Section 820G, delivery of director's written consent. Section 820H. Please hold on. Legal advisor has a question. On 820G, subsection 2, there is an offense created. According to this part, if the director's written consent is not submitted, it will be an offense. It is an offense with strict liability. We understand that an honest and genuine mistake would not be a defense. We want members to pay attention to this. In relation to the offense mentioned in Section 820G, we asked the administration whether it would be included in Schedule 7, a list of offenses. And the list of offenses in Schedule 7 is punishable by fines. The administration said it would move a CSA to include this offense in Schedule 7. So this is just for members' reference. Thank you. Please carry on. Section 820H. Reporting duty of redomiciled companies after registration under Section 820C. We made reference to the requirements concerning reporting obligations under the existing companies ordinance. Clause 69 onwards. There are consequential amendments. Page 137. We are adding bracket AB so that the provisions would apply to the redomiciled companies. According to the original ordinance, if the financial secretary is of the view that there are frauds involved, it could appoint an officer to initiate an investigation. Page 138, Clause 70. We are amending Section 905 about litigations, and the relevant provisions will not cover redomiciled companies. Clause 75, page 139. Like the Deputy Secretary said, Section 911 gives the Financial Secretary and Registrar the power to amend schedules. We're including Schedule 6A, 6B, 6C into this provision so that the Financial Secretary may amend these schedules. Please hold on, Dr. John Nias Ho. Sorry, I might be a bit behind. You were talking about Section 820G. The legal advisor talked about Schedule 7. That is, the offense created will be included in that schedule, and you will move a CSA. I see that some offenses would be punishable by a fine. Would all these offenses be included in Schedule 7 to ensure consistency? For example, Section 820H, subsection 5. It says it is liable on conviction to a fine at level 4. And in the case of a continuing offense, to a further fine of $700 for each day. Would this be included in Schedule 7 as well? For all these kinds of offenses that will be listed out in Schedule 7, the CSA that we're going to move will make all these offenses included in Schedule 7. That means the offense mentioned in 820H is different from that of 820G, correct?
All right, please proceed. Clause 72. It amends Schedule 2. It is a technical amendment, so that we will add a reference to Section 474 for ease of reference. Clause 73, it amends Schedule 3. We are amending the definition of non-Hong Kong body corporate to say specifically it does not include a redomiciled company. Mr. Yin Kong. Schedule 3, I have some questions. I would ask the administration to review this. We are talking about non-Hong Kong body corporate. It refers to pretty much the same thing, but we're no longer using the word corporation. As I said earlier, we see different terms. We body corporates, companies, corporations. I urge again the administration to review why so many different terms are used to describe pretty much the same thing. Administration, please give a response later. The distinction between companies, corporations, body corporates after the meeting. Thank you. We are now talking about a clause that adds Schedule 6A, Clause 76, information and statements to be contained in redomiciliation form. so that they will need to make sure redomiciliation form contains the name of the applicant, the place of incorporation of the applicant, and information as to whether the applicant is a non-Hong Kong company. Schedule 6B is on other directors and company secretary of the redomiciled company. Schedule 6C would be on the particulars, some documents that have to be submitted for proof. Mr. In Kong, excuse me, I want to ask about, say, for particulars of legal entities. Right now in Hong Kong companies, how are they different from the requirements for Hong Kong incorporated companies? Apart from difference in wording, are the requirements the same? Schedule 5B, Part 4. What is the difference exactly? You have included much information here, but what exactly is the difference? Say in 4.2, let me be clear. You're requiring some particulars to be provided. So what is the difference while you have provided for particulars of legal entity here? Are we referring to page 142 of the marked up copy in Chinese? Yes, Schedule 5B. Why I'm asking this question is this, because on the right hand side you are requiring, say, the registration numbers and addresses. Why do you need to be specific? Too specific here. I'll let the DOJ colleague answer this question. Thank you. There is a difference when we're talking about C1. We need to talk about how the companies have never been redomiciled. So in A, we would ask for the entity's name and the certificate of incorporation. But then in 2, we are talking about redomiciled companies. So in A, we need to talk about the latest domiciles, proof for the company's registration in that domicile. So that is the main difference. Chair. So why can't we say in 4.2b, say B1, that they have previously registered their registration numbers? I'm sorry if I'm wasting time here, but let me say this. I think the drafting can be so much simpler. We have added a lot of things, but then it is actually the same as what we have in requirements for other companies. So why do we have to draft it in such a complex way? Well, I think the company's registry colleague may supplement my answers later. But in drafting the provisions, we have considered what the company's registry would want from the companies. Would they want something that the company has in history, all of their registration numbers? I don't think so. I think in general, for Hong Kong incorporated companies, we would want the registration number on their certificate of incorporation. And then we would require for domiciled companies the certificate of redomiciliation. But then we will also require the registration numbers on the certificate of registration of their last domicile. I don't think the company's registry would want all the numbers that the company previously had in different jurisdictions. So I think this is how we can reflect this in drafting. Companies registry, anything to add? Well, with the new C, we are trying to clarify this. With the redomiciled companies, what they are to submit in documents. As the DOJ colleague said, if the company redomiciled more than once, it would be covered by the part under Roman numeral 2. So with redomiciled companies that are redomiciling for the first time, they will be covered in Roman numeral 1. Ms. Carmen Khan. I want to refer to page 139 of the marked up copy in Chinese. The administration talked about adding schedules 6A, 6B, and 6C, and the requirements for redomiciliation. The documents required would be different for different jurisdictions. So apart from section 113, page 139 of the marked up copy in Chinese, section 911, that would allow the financial secretary to make changes to the schedules. This is not exactly a flexible approach. While they did say it would offer some flexibility, for Hong Kong incorporated companies, it's much simpler. For redomiciled companies, it seems that it does not offer much flexibility. It is very restrictive. Is it going to be attractive to companies or the consultants of those companies? It may seem hard to comply to the requirements, and if you said the registrar must refuse the application if the requirements in the relevant section are not complied with, and you're talking about what documents to submit here, I think it's more proper to include schedules 6A, 6B, and 6C in a regulation instead. I want to ask, for the schedules under section 911, are they subject to negative vetting? I think you should really try to strike a balance between delegating the power to the company's registry or company's regulations, or just leaving it here. Deputy Secretary, or Eric. Excuse me, I think there are some minor differences. I don't think there are minor differences. We're talking about companies incorporated elsewhere or have another domicile. Why do you have so specific with the requirements? Because different jurisdictions may have different documents, right? I think you should offer more flexibility. We do note your suggestions, but in section 820B4, if the registrar requires more information, they may request that the applicant provide more information. I think it may not exactly address the members' concerns, but to a certain extent, the registrar may have reference to different jurisdictions' practices or any changes in the jurisdiction's practices. This is a catch-all provision. I would say that this is not justified. I think you need to, when you're talking about people having to rely on section 820C4 for justifications, but do you provide flexibility in terms of the actual requirements? Deputy Secretary, any response? Well, with our requirements, it does not tailored to a particular jurisdiction's practices. we are trying to strike a balance between the potential risks and what information we need. We have some companies domiciled overseas, and I think they can provide us with some background information to help us vet their applications, including their membership and their financial situation in the past year, whether the company is in debt. If available, the original documents for incorporation in another domicile. We believe for an incorporated company, even if it is a company incorporated elsewhere, it should be able to provide background information like such for our processing. And this is indeed very important for our processing, and we believe any changes can be made through subsidiary legislation. Thank you. Please proceed. We were on Schedule 6C, documents to accompany redomiciliation form. The applicant also has to submit a certificate signed by a director to confirm that it is not subject to any winding up petition, and that the decision of redomiciliation, the message has reached the relevant members, and they also have members' approval to redomicile to Hong Kong. There are also some other rules, for example, requiring a legal opinion to be submitted. So that is in general what is needed for information and statements.
Clause 77. Page 172. This is a technical amendment. Point number 9 under Schedule 7. We're adding the relevant numbers of the subsidiary legislations concerned. Next page, we are again amending the Chinese definition of registration. Next page, we're adding Schedule 12 to add the deeming provision introduced earlier. These are all the amendments to the company's ordinance. I'd like to go to C3895 of the Blue Bill. It's about 75% of the eligible members. It's about the special resolution obtained in the General meeting. Are you going to make an amendment? C3895 of the Blue Bill. Let me give a brief response and then I'll ask the DOJ to supplement. If the place of incorporation has the laws asking for 75% of the eligible members to give the consent. If not, we ask the 75% requirements to be fulfilled. We looked at laws in Cayman Islands. There's a relevant legislation about the percentage of the eligible members. So here we refer to 75% of the members present in a general meeting to pass the resolution. C3895. We made reference to a special resolution requirement in Hong Kong for major decisions to be made. A lot of the companies adopt the 75% threshold. We ask redomiciling companies to provide this proof showing that members of the company agree to the redomiciliation. Yes, Dr. Junius Ho. It says here, at least 75% of the eligible members. Some of the members may not be present at the meeting, but they are considered as eligible members. Is that right? So 75% of the eligible members and 75% of the eligible members present are different, right? DOJ. We drew reference from the practices in other jurisdictions, and they also adopt the 75% threshold. According to the laws of incorporation, if there is such a requirement in the original domicile, or if there is such a requirement in the constitutional document, we stick to the requirement. If there is, however, no relevant requirement, we also impose the threshold of at least 75% of the eligible members who have the right to make a decision at the meeting to pass the resolution in order to meet the relevant requirements in Hong Kong. So we want to be able to play a gatekeeping role as we drafted this provision. We understand that the administration tries to be the gatekeeper. However, we're concerned whether the wording should be eligible members or eligible members present. Say there are 10 members and 8 members agree, then the resolution could be passed. But if I'm talking about a private company with 50 members, 75% of the eligible members would be about 39 members who need to pass the resolution. So it would be different depending on the scale of the company. I think Dr. Junius Ho shares the same concern. What is the administration's take on this? As explained, the 75% threshold in the context of companies' ordinance is about 75% of the members present at the meeting. In the context of redomiciliation regime, we will see whether eligible members mean a different thing. But as far as I understand here, it means 75% of the eligible members present, even in this context. Companies registry. We intend to mean eligible members present at the meeting. Yes, Dr. Junius Ho. I understand that the 75% means the number of members present at the meeting. If you look at the blue bill, C3894, Section 4, subsection F. It says here that if there is no relevant requirement, a statement confirming that a resolution has been duly passed for the redomiciliation by at least 75% of the eligible members. It doesn't spell out clearly here that it is referring to eligible members present. If you aren't referring to eligible members present, the threshold would be a lot higher. I agree. In the previous meeting, I already raised this question about whether you're referring to eligible members present or just eligible members. In some situations, you may need all members present at the meeting to pass the resolution. And the definition could be different in different contexts. I wonder if the administration would enhance the clarity here. We've already explained the policy intent on the wording. We'll review how we can make it clearer. Ms. Carmen Khan, I'm following up on the same point. If you just look at the provision here, it does not clearly reflect the policy intent. If you look at C3894 of the Chinese version and C3897 of the English version, For the definition of eligible member, it just says, in relation to the redomiciliation means a member who under the law of the place of incorporation and the constitutional document of the applicant is entitled to vote on a resolution for the redomiciliation. It doesn't imply members present at the general meeting. It only says members entitled to vote on the resolution. So it's not that we have a consensus here at the Bills Committee and it will become the law. I think you have to spell it out clearly in the bill. Bracket F here only says eligible members. Please hold on. Deputy Secretary. The DOJ may be able to provide you with some information about the definition of eligible member. Yes, DOJ? C3897 on the definition of eligible member. There is a definition. If you look at Schedule 6A to 6C with reference to eligible member, you may refer to the definition here. According to the definition, eligible member means a member who, under the law of the place of incorporation and the constitutional document of the applicant, is entitled to vote on the resolution for the redomiciliation. This is what eligible means in this context. Member is correct that it doesn't imply members present at the general meeting. But this provides the definition of eligible member in other jurisdictions, including the original domiciles. So here we define eligible member as a member who is entitled to vote. Ms. Carmen Khan, that's why I say it is unclear. You're requiring the redomiciling company to provide a proof showing that at least 75% of the eligible members agree to the redomiciliation. The DOJ just now read out the same definition in the bill. According to the definition here, an eligible member is a member who is entitled to vote on a resolution. But the resolution may not be passed at the setting of a meeting. Yes, we had a similar discussion in the previous meeting. I think it deserves the administration's attention. For a private company, it consists of 15 members. Say, if we have a company with 500 members, 75% means a huge amount of members. Yes, Chairman will see if we can enhance the clarity here. I will extend this meeting by at most 15 minutes. We will conclude the meeting after Ms. Doreen Kongs has spoken. Ms. Chairman, I have another question too. We'll let Ms. Kong speak first. We have to ensure that the incoming company transfer their domicile according to the company's constitutional documents. Here, it says that if there is no relevant requirement, at least 75% of the eligible members will have to agree to the redomiciliation. For jurisdictions with a similar inward regime, do they have similar provisions in their laws? do they impose a rigid requirement of 75%? Is it the same in Singapore, New Zealand, and Australia? Deputy Secretary, in Australia and New Zealand, they also impose a requirement of 75% of the directors. How about Singapore? Well, I don't have the relevant information in hand. Chairman, I ask this question because we want to ensure clarity of this provision. We have to compare our practice with the others. If our competitors do not impose such a stringent requirement, I don't think it's necessarily a good thing for us to impose such a rigid requirement. Ms. Kamen Khan, I'd like to go back to page 130 of the marked up copy concerning section 820D. According to section 820D, subsection 1C, the fact that a body corporate is registered under section 820C1 does not render defective any legal proceedings commenced or continued by or against the body corporate. I think this part will have to be looked at together with the subsection B. Say, when a company fails to deregister from the original domicile, our court should not deal with the relevant legal proceedings. Within 12 months' time, the certificate of solvency will be issued, but within these 12 months, there might be problems. The legal identity of the incoming company will not be changed, but there might be legal proceedings commenced or continued by or against the company. I wonder if a provision can be added here stating that the court in Hong Kong will not deal with any legal proceedings before the deregistration procedure is completed to avoid any confusions.
我諗
The DOJ can go back and think about this. Yes, Mr. Pose. Regarding the point made by Ms. Kamen Khan on the last point, I disagree in a way. If we can let the company choose when to start or where to continue with the proceedings, it will not conform to the jurisprudence principle. There may be some injunctions issued, or there may be some proceedings that would have to continue. There may be disputes that may arise because another party may say it is inconvenient to go on with the proceedings, but this should not be in law because there may be different reasons and justifications, and I hope the DOJ can review this with reference to such scenarios as well. Ms. Kamen Khan, my suggestion is to have the DOJ review the practices of other jurisdictions, and can we be more particular, for example, for interlocutory or some other solvency proceedings that we spell out what is going to happen? I have dealt with some cross-boundary liquidation cases. Some may accuse fraud, and their situation is quite complex, and some may have proceedings transferred to Hong Kong upon redomiciliation. I think we should really refer to the practices of other jurisdictions, but I do take note of what Mr. Paul Tse said. We should strike a balance. Indeed, we should strike a balance. All right, I'm ending the discussion of the meeting today. The next meeting is to take place at 4:30 p.m. on 25th of February. Members, do you wish to propose any other business? If not, meeting adjourned. Thank you.